Good evening, everybody. This is the makeup class of October 1st, 2002 in property. The class is being held in advance of the class that we're making up. For those people who are not here, out of about 70 people enrolled, I'd say 68 are here. Is that right? But everybody's here, so if you missed it, we're very sorry about that. Well, in this class, we're going to talk about land transactions, which is the last of the topics in the portion of the course about the acquisition of property. And you'll notice that there's huge amounts of coverage of this in the book, but we're spending very little time on it. The reason we're spending so little time on it is because so much of it is regulated by statute and specific to the jurisdiction in which one practices, that I'd advise people who are interested in going into this area of law to take relevant courses that really focus on how these kinds of transactions work. In this part of the course, what I want to do is to direct your attention to some issues that relate rather closely to a number of the principles that we've been studying already, and to use this material to enhance your understanding of the materials that we've been looking at thus far. That's why we're doing so little of it, certainly not because it's uninteresting or not of practical import. Obviously, it's both interesting and of practical import. Can't do everything, though, and I thought this was a reasonable way of designing this part of the course. Well, there are materials in the beginning of the chapter that I asked you to read that talk about how a purchase and sale of a piece of property work, and there's nothing, anybody who's been involved in such a transaction understands this. It's, the steps basically are you find a piece of property and agree on a price. Secondly, the parties enter into a contract. Third, typically financing is needed. The contract is typically contingent on the buyer obtaining financing. If they can't, then they can't buy the house. And they can't really try to get financing until they have agreed in a contract so that the financing institution knows what the price is going to be and knows other things about the house. So that's the way that's usually handled, that the contract is contingent on a mortgage being obtained. Title work is needed so that the history of ownership of the property is something that the buyer, the seller, and the financing institution all agree upon. Then the title assurance is obtained, and there's a closing. That's basically what happens. If anybody's bought or sold a house or a condo or a co-op or any piece of property, probably went through more or less those stages. And the reading is those notes on that issue. I hate to have this recorded, but it's not the most exciting part of the book. The question that I want to ask here, though, is why do you need a lawyer for? Do you think you should? Should you really need a lawyer for that? Why do you need a lawyer?
Because even if you think you know what the laws are, you never really are prepared. And also when you're buying a house, it's probably emotional, and you get caught up, and you really need someone to hold your hand and take and ride you along. And even with simple things like refinances, where people will tell you don't need a lawyer, I'll tell you if you don't have a lawyer, the bank will put in those extra charges where you really wouldn't even know you're being charged.
Can you give an example?
Sure, per diem interest. They'll tell you during your 3-day right of rescission period, they'll charge you for it. And if you have your lawyer there who will fight for you, will say, well, why should they pay for the 3 days where they don't even have the money? That would be one example. Or another example would be if you're entitled to a reduction in certain charges, you wouldn't be given that reduction unless you ask for it, and you wouldn't even know to ask for it.
What about the relationship between the buyer and the purchaser? Again, why would the buyer want to have a lawyer?
Well, the buyer would want to be protected. and he wouldn't even know what to protect himself against.
Well, can you give some examples as between the purchaser and the seller as to what the purchaser might, why the purchaser might need a lawyer?
Well, in terms of drafting a contract, you need a lawyer. And especially if you want to go get a mortgage, you have to have it all done legally. I mean, I wasn't even thinking of drafting a contract without a lawyer. That I don't think is even possible.
Well, has anybody bought a house or knows somebody who bought a house and there were issues with respect to the contract that, for which legal advice was appropriate or necessary? What kind of issues arise? Yes?
There's always debate about, especially if you're a first-time buyer, it's debate about who's going to pay for the cost, who's going to be there, who pays for brokers, these types of things, especially if you're using an agent and just signing some fake contract. You don't consult a lawyer, you don't know that you can ask for certain things, especially if you're a first-time buyer, you can ask for special things to be done for you.
But why not rely on real estate agents?
The site is not back, they usually don't have a law degree. Sometimes.
But they really know what they're doing with this stuff. I mean, they've done dozens of these closings at least. Why wouldn't you want to rely on your real estate broker?
Well, in my own personal experience, some real estate agents might have an interest in selling a particular piece of property. And for me, my husband and I were looking at buying a condo, our particular agent had an interest vested in selling or pushing a particular set of condos. And taking his advice along is the best thing to do.
Right, somebody else?
I think it's true, conflict of interest. If they're interested in selling property and make a commission, whereas a lawyer's interested in represent you and, the best path.
So when nothing goes wrong, maybe you didn't need a lawyer. So if you agree upon a price and the contract gives you less than the appropriate inspection rights than you really would get if you had a lawyer, but the house is in great shape anyway, and the issue of who's going to pay for certain problems if they arise, that was never resolved, but no such problems arose, so that's okay. And there may be issues with the bank, and the bank might have taken advantage of somebody, but it didn't happen this time, so that's okay. So there are lots of little things that go wrong, and sometimes big things that go wrong with respect to rights to inspect property, how much caveat emptor is there, and so on, which sometimes you either need to know what your rights are yourself, or you need somebody to advocate for them. Real estate agents are in the business of selling and buying, of helping people sell and buy property, and they get commissions. So ultimately, even the nicest real estate agent is in a situation where what they really like to see is the property close and for a check to go to them at the closing. That's how they make their living. It doesn't mean that they're inherently dishonest people. Of course, that's not even remotely true. But it does mean that if you are making the biggest purchase of your life, and it's a rather frightening experience, then if you think that the real estate agent who's been so nice to you is on your side in the sense that they want to make sure the very best thing happens for you, of course they're not. By the time you get very close to the closing, they want to see the deal finished. Even if they're perfectly decent people, they want to see the deal close, and they want to see it close more or less fairly. But if this or that $2,000 goes one way or as opposed to the other in the context of a rather large financial transaction, it might not be as important to them as it is to you. So that's, I guess, why one would need a lawyer. Now, it's very interesting. In a lot of places, they don't use lawyers. The closings occur at the title companies, and the people who run the title company make sure that all the paperwork is done. In fact, as far as paperwork is concerned, even when you have a lawyer, lawyers who do this routinely have their secretaries or their paralegals or somebody draft all these papers. There's a big wheelbarrow full of papers that you have at a real estate closing, including disclosure statements, all kinds of paperwork involving the mortgage, and so on. And, attorneys don't sit there and type all this stuff out. There's a staff of people who know how to do this, and then they review it. Often that's looked at as what the mechanics are, and in a lot of places, you go down to the title company, and the title company, for a fee, takes care of all this paperwork for both sides. You go down with the real estate brokers, and you finish the deal, and you close the house. In New Jersey, there have been disputes for years. The southern part of New Jersey having a culture in which you don't need a lawyer, and the northern part of New Jersey having a culture in which you do have a lawyer, and the courts siding with the northern part of New Jersey rather than the southern part of New Jersey. The question is whether they're siding with them because the New Jersey courts are rather protectionist of the legal profession, which I think may be true in some instances, or whether they're siding with the lawyers because it's really in the client's interests to have lawyers. And I think the remarks from the class have covered the reasons why it might be a good idea to have attorneys involved in these things, even if they don't do very much. For simple real estate transactions, lawyers typically don't charge very much, and if they do a good job, they see to it that the contracts say what they're supposed to say, that the parties aren't overcharged by the banks, and so on. Complex real estate transactions involve lawyers' involvement in negotiations and actually drafting the contract either from past files in which they have other complex transactions they've done, or really from scratch as new agreements. People who are interested in going into real estate law, especially involving commercial kinds of transactions, it's really a very creative area of law where you have to take into account a great deal of law and the business needs of your clients. But even for simple transactions, I've bought a few houses, I've sold a few houses in my life, and I don't know the local law in New Jersey where I live with respect to all of the details or all the practices. I hire a lawyer. I always do. And I think that takes care of that question. I think it's really the core question of the first part of the materials. Now, turn please to page 612. And what I'd like to do is this is the general warranty deed that's in the book. And see that $10 plus other good and valuable consideration is what's in the deed. Why would it say that? Why wouldn't it say what the amount is? Yes?
Is it anybody's business? I mean, deeds get recorded. Why does it have to be public record? Why don't you just pay for anybody's house?
Well, I'm curious.
That's why it shouldn't be there.
And that is why it's not there, just to protect people's privacy. There are public records of land transactions, but this is not but this is not where they always are. And obviously, parties would like to make it difficult to know what they paid for property, because if they want to sell the property, they like that. They'd like the market to influence it. They don't want somebody to be able to say, "Well, I saw that you paid $92,000 for this, and now you want $270, and it's only been a couple of years. I'll give you $240." That's a discussion that obviously people who are buyers and look at themselves as potential sellers would rather not have. And the deeds, some deeds put in the amount of money. It varies from state to state. But in some deeds, they're able to put this sort of vague language in to insulate the terms of the transaction from public scrutiny and to protect the buyer with respect to other transactions they might want to have. What I really want you to look at in this deed is what the warranties are. It's called a general warranty deed. And it says the grantor covenants, and there are a half a dozen warranties. One, that the grantor is lawfully seized in fee simple of the premises. Two, that he has a good right to convey the fee simple. 3, that the premises are free from all encumbrances. 4, that the grantor and his heirs and assigns will forever warrant and defend the grantee and her heirs and assigns against every person lawfully claiming the premises or any part thereof. 5, that the grantor and his heirs and assigns will guarantee the quiet enjoyment of the premises. Now, that doesn't mean that the grantor will come back anytime there's a noisy neighbor, obviously. What does it mean? How can you guarantee the quiet enjoyment of the premises to the grantee and her heirs and assigns? Yes?
There's title insurance on it, just in case anybody comes against it with a claim for...
Competing claims, that's right. Or the grantor is saying that if there are any competing claims, other people trying to put you out, that's our problem. And 6, the grantor and his heirs and assigns will, on demand of the grantee or her heirs or assigns, execute any instrument necessary for the further assurance of the title to the premises that may be reasonably required. Now let's go back to the adverse possession cases that we talked about last week. And there were a number of cases where there was an adverse possessor that was around. And remember, I told you that property is bought and sold subject to the rights of adverse possessors. Here in New York, where the adverse possession period is 10 years, if a purchaser buys a piece of property and there has already been an adverse possessor on that property for more than 10 years, it's not the adverse possessor's problem that the property switched hands. So the adverse possessor sometime can say, well, I've been here for 10 years, and the new purchaser goes, well, I just bought this property. What are you talking about? Not only can the adverse possessor say tough, but the courts will say tough. That is, remember we talked about tacking. Adverse possessors can tack, but the title owners do not interrupt an adverse possession period by selling property that was subject to adverse possession. In fact, that was our explanation of the Kunto case. It's really what ended up happening. The adverse possession had already matured decades ago, putting aside what the court's analysis was, that was our analysis. Then there were numerous sales of a house that had already, whose ownership had already matured through adverse possession. It really wasn't a very hard case at all. That was Professor Jones's insight into that case. So now we have a situation where the title holder sells the property, the new purchaser buys the property. There's been an adverse possessor on the property for a long time. The adverse possessor either brings an action to quiet title against the new owner, or the new owner tries to bring an action in ejectment against the adverse possessor. The adverse possessor will win either of those cases. So what rights does the new purchaser have at all? What are the legal rights? Yes?
Are we talking of the purchaser who got a general warranty deed?
Yes.
Then he goes against the seller.
So he can go against the seller. So he has title insurance, number one. So as far as he's concerned, if he has a problem with the title, he's insured himself against it. Who's going to insist that he insure himself against any kind of problems with the title? The lawyer. Well, the lawyer's going to protect him. And he's going to, yes?
Well, if you bought it for a mortgage, the mortgage company?
Yeah, nobody's going to want to lend money secured by a piece of property and then find out that that security is no good, they don't have any collateral on their loan. Mortgage rates are lower than unsecured loans precisely because they're secured by the property. Mortgage company can always, at least in principle, foreclose and sell the property and get at least that much of their money back, which is often all of their money. Yes?
I'm confused about something. In terms of getting title insurance against adverse possession from the prior owner, that's what this general warranty deed is. But to get title insurance from a title company, they won't insure you for adverse possession.
It's excluded?
I checked today.
Oh.
It's not included. The most that you would get from a title company is if you have a survey and they notice an encroachment, they'll tell you that you might be likely to lose that 1 foot of land.
But they will not,
won't insure.
they won't insure with respect to adverse possession.
No, exactly.
Well, if that happens, your only claim is going to be against the
Seller.
previous owner, between the seller. Now, what does the seller have now?
Well, if the
The seller has your money. So if this happens quickly enough, the seller will have assets. If the seller has since moved to a continent very far from where you are, you just lose altogether. I'm sorry, I interrupted.
So, but that means when you get a general warranty deed, that's the best insurance you can get against adverse possession, because if you don't get a warranty deed from the seller, then you'll never have insurance on adverse possession.
Well, you won't have a promise that was broken as clearly as this one was. That is, when somebody sells property, and most deeds are warranty deeds. They for the purchase and sale of property in everyday life. So typically speaking, what happens, you buy a piece of property and the deed looks something like this. I'll tell you what the typical exceptions are in a few minutes. So the deed looks something like this. Then you have the right to go after the seller for particular, for breaches. These are promises that were made. It's conceivable that you'd have a right to go after them anyone, but here you certainly have a right to sue a seller for breach of warranty, whatever your loss was. So these warranties are really taken very seriously, and some of the cases we're not reading in the book involve the warranties here. Lots of times when we're talking about adverse possession, people who were upset and sort of surprised at the doctrine were asking, well, what can you do? This is one thing you can do. You can just go after the seller. They have no right to sell you a piece of property that they didn't own. So this is really the answer to the other part of the question. Now it says there are no encumbrances. Of course, there typically are encumbrances. So it would say no encumbrances except those listed on Exhibit A to this deed. And remember, we talked there are typically a whole lot of relatively minor easements, sometimes more significant easements, with respect to the property that's being sold. The one encumbrance that you want to make sure there isn't is what? When you buy a piece of property, what do you want to make sure does not encumber that property? Yes?
Taxes, judgment?
What, taxes in particular, what else? A mortgage. You want to make sure that that property isn't secured by a mortgage that isn't going to be paid off. And then there's a title for a security interest that an earlier lender has in the property, and that's really very typical. That's why mortgages are recorded. The book has something of a recordation system. It would be very foolish to lend money on a house and not record the mortgage. Once you record it, obviously, any new purchaser will be on notice of your interest in the property. If you don't record it, then you have issues of notice and so on. That becomes seriously problematic. So that's how what deeds look like and how they're relevant to what we've been talking about. And obviously that's why I put this particular section of the course right here, right after adverse possession. Any questions thus far? Yes?
It just seems to me that when we discussed Professor Jones's theory last week, it just seems to go against everything that we've learned in terms of repose. Why does an adverse possessor never have to worry about a statute of limitation? Why does it just go on forever? If somebody can find out that a prior owner, even 50 years down the road before him, could have made a claim but didn't, that could put him into a very strong position. He shouldn't. Why should he have that right?
I think that case really illustrates why they should have the right. Was there anybody who would like to answer that? This side of the room is really quiet. Yes?
Does it go back to efficient use of property? And the fact that the law in this particular case is trying to promote people taking the land, using it, even if it may be a little anachronistic in today's society, but just the root of it was a little more.
Well, in Howard versus Kunzel, when you take that case, you have decades ago, 70, well now it's 70, but 50 years ago, somebody has a piece of property, A has a piece of property, sells it to B sells it to C sells it to D, and now F is living on it. It turns out that the deed that they've been transferring from one owner to the next misdescribes the property, and somebody with the deed to that actual property comes out of the woodwork. But they haven't lived on it, neither is any successor interest, and it's almost kind of a nasty gesture to try to kick these people off of the property. But there's a series of deeds, just everybody had the wrong deed in this particular Puget Sound summer community. So given that, how would what you say fit in?
Well, because regardless of the mistake, you have this long period of succession where people are living there, maintaining it, and just out of practicality, set of practices.
So there's a certain amount of expectation that's been formed here by the generations of people who live on the property, being able to keep it. Do you really think they should have been able to kick them out of the house?
I'm not talking about that. I'm talking about, let's say, the two old ladies that had that trellis, right? Okay, and let's say that they sold the house, and the trellis was there, let's say, for 10 years, and then it was removed. And then some guy wants to extend his house, and he finds out, hey, wait a minute, I can even go back even further, because that old lady who owned it 50 years ago, I have pictures of that trellis that she has, and now I can claim adverse possession. That's what bothers me. I don't think that's efficient use of property. I think that's giving somebody leverage they shouldn't get in the first place.
So what you're concerned about is somebody being surprised, really, by... I mean, nobody's going to be surprised at Howard versus Kunto, right?
No.
I mean, you think that one's okay?
That's right, but I'm talking about if adverse possession runs with the land, like an easement does, and if someone doesn't, my problem is that if someone doesn't enforce their right, and then they sell it, and three links down the chain of title, someone decides that they want to take advantage of that, that's not efficient use of property.
So if it looks like there's some kind of neighborly relationship, I think what you're talking about, let's take this hypothetical we had where these two people have they're neighbors, they're good friends, and one of them has the trellis on the other people's property, and everybody is just sort of relaxed with that. But then it's possible to prove that that was going on 2 generations later, and who's to prove that that happened with permission? So it may be possible to make adverse possession claims by taking advantage of situations. Well, to the extent that adverse possession leads to that, that would be a serious problem. But I'm not quite sure it happens that way. Yes?
I was just curious, is there any case like that?
Sort of. I mean, there are cases where people are just sort of relaxed in the way things are working, and then the next thing you know, they find they lose something.
But if they've been there for 10 years, then the statute of limitations run already, and now it's theirs, right?
Well, that's right. The problem occurs when you buy a piece of property after which an adverse possession has matured, and you don't really focus on it, or you don't really know about it. And had you focused on it, you might have paid a different amount of money for the property or not bought it at all. That's with respect to a piece of the property. You don't have so many cases where you buy a piece of property and the whole thing was subject to adverse possession. That's kind of what's interesting about Howard versus Kunto. But these cases where there's a piece of the property that you thought you bought, you didn't, because somebody comes and says, well, no, this is what we've been, or you see it much more with prescriptive easements, really, than you do with adverse possession itself. When it happens, it's sometimes disturbing. It's the flip side of the doctrine. Anything else so far? Yes?
I think I'm a little confused, so we need to back up for a second. With the hypo that we had the last time with the trellis and the two neighbors who were friends, I thought that we were talking about, I thought in that case we were getting away from adverse possession, and we were saying that, they were friends and a lawyer could advise a revocable license, and then in that case they wouldn't have a claim?
Right, the timing in that hypothetical was, that's right, they were having this discussion prior to the expiration of the adverse possession period. And I was, what I wanted to accomplish by having that discussion is the fact that we study the law by reading cases doesn't mean that cases obviously occur after people, any relationship between people is broken down and they're having a major legal fight. You don't really have to deal with these situations that way. If you get them in advance before a serious problem is brewed, you can actually help create decent relationships among people without waiver of rights. You don't create a decent relationship, you can preserve a decent relationship among people without a waiver of rights. I'm talking about the same physical situation, but what happens much later. That's really what the discussion is now, is what happens if 2 generations later of people buying these things, looking at the deeds, seeing the fence, not making a big deal over it, all of a sudden somebody says, guess what, we have adverse possession, and they win, and catch somebody off guard. The comment was that really seems pretty severe for people basically trying to relax in a neighborly way. Well, it is severe. It reflects relationships among neighbors that the law recognizes that seem to be more arm's length and than the reality of how people think they're related to each other. I don't think there's any question about that. Yes? Yes.
In that particular situation, though, it's 2 generations later, and say that the 10-year period had passed again since the removal of the trellis, couldn't the next possessor of the land begin adverse possession on that parcel of land, and then it would continue through anyway?
Well, if something like that happens, yes, you
The
can.
statute of limitations would
Right.
run out again.
Right. I mean, you can, things like that, they mostly happen in hypotheticals and the problems in case books, but in principle, that kind of dynamic can occur, yeah. Yes?
So instead of a written revocable license, can parole evidence be admitted to prove that there was actually some kind of agreement between the 2 neighbors for the other one to use the piece of parcel for the house?
Oh, sure, because yes, adverse possession typically has to be proven by clear and convincing evidence, and you have to show that you've met all the elements of it. And one of them is that it's adverse and hostile, meaning hostile to the ownership rights of the other, not with a dirty look on one's face. And so evidence that it wasn't under claim of right and hostile, and those elements sometimes sort of combined as a matter of proof, it's exactly what you're talking about. So what are you talking about? We had discussions all the time. We understood that it was there. We talked about what flowers she would put on the trellis. We're both into horticulture. The fact that she put up the trellis, she was more serious about a particular kind of plant that grew better there. I let her do it. We talked about it. There was never any claim that this was now her property. In fact, quite the opposite. She always thanked me for letting her stay on the property during this period and so on. It's obviously not a great idea, though. The reason that's not a great idea is because if the first time somebody has a stroke and the nasty child who moved out to Chicago comes back, it might not be that anybody recalls any of those conversations. Then you begin to have problems. So it would be much better in a situation like that, just to have something in writing. And, if it's 2 nice people and they're not used to dealing with lawyers, some of the cases are about situations like this, where somebody else steps into the scene, and while they were having a fairly decent relationship that's sort of community-oriented, the relationship changes when new people who are strangers to one another are the ones who are determining the legal rights. Obviously, it's much better to protect oneself with a short letter agreement that's not a very big deal, doesn't cost a lot of time or effort as far as lawyers are concerned, but states what the rights are going to be. A bad solution is to make people tear down fences or trellises because you remember that you studied adverse possession in law school and you're a nervous lawyer. You'd rather put those kinds of property rights above people's ability to try to get along with one another and have a nice life with their neighbors. Another thing that happens is people often do nothing, and some of the cases, well, wait until you see the cases on joint ownership. were the people who get burned by lending money to relatives or friends when there's a joint ownership. They don't know any better. Banks don't do that. Banks protect themselves. Neighbors, aunts, uncles, and we'll see some of it today when we talk about the Rosenkrantz case. Yes? Anybody else? Okay, well, that's really all I wanted to do with respect to that. Now let's move on to talking about delivery of the deeds. And these cases also relate to issues that, some of which we've already come across and some of which we will come across soon. There are two cases that deal with delivery of deeds in the context of real estate transactions. And the first one is the Sweeney case, which is on page 633. Now, here's what happened. Maurice Sweeney had been estranged from his wife for some 20 years before he died, but they never got divorced. And he owned a piece of property, and he decided to give that property to his brother, John. And then John, and he did that by, they went to the Hall of Records, and they asked the clerk at the Hall of Records to make a deed from Maurice to John, and they did. These things, incidentally, these deeds are on a pad of paper that you can buy. The details of them have to be typed in as to what the various warranties are, any encumbrances, and so on. If there are differences in the warranties from the standard deed. But you can go and get a standard warranty deed, and it's printed, often it has italics, because you think if you just spent all that money, you deserve italics, or some kind of Gothic script or something. Wills have that, apparently, on the theory that if your will has that kind of print on it, you won't die. People used to die in the Middle Ages. We don't die anymore. That's why we have this script. And so you can get this deed. They did. They went down to the Hall of Records. They asked the clerk to fill out a deed. It doesn't really work that way now, but they did fill out, the clerk accommodated them. That was from Maurice Sweeney to his brother John Sweeney. And they recorded the deed in the Hall of Records. So John Sweeney now owns this property, even though Maurice continues to live on it. Then, right after that, they got another deed, tore another one off the pad. And this deed was from John Sweeney back to Maurice Sweeney. That's the second deed. What happened to that second deed in this case? Yes?
It burns in, the brother John's had an attorney's office and it burned down.
Well, that's ultimately what happened. So, but let's trace what handed that deed to whom, because it matters.
It was deeded to,
From John to Maurice.
under the circumstances that, it was protected just in case, I guess, John died before Maurice. Is that what you're looking for?
So Maurice says, gee, just in case, Maurice says to John, I'm living on this property, but just in case you die first, you better give a deed back to me. And he does. And then physically, what does Maurice do with the deed? John gives Maurice the deed, hands it to him. They agree on this. It takes 5 minutes. They just fill out this other form. Yes?
They recorded it, the first one.
The first one was recorded. We're talking about the second one. Just physically, what did they do with the deed? Yes?
John kept both of them, gave one to his attorney.
He hands it to Maurice. Maurice hands it back to John, just for safekeeping, along with the copy of the recorded deed. When you record a deed, often you'll want the clerk to stamp that a copy that they give you, indicating that this is a true copy of a deed that was actually recorded. So he has the recorded deed, and he has this unrecorded deed. Maurice just says to John, just hold this for safekeeping. And now we'll get to the lawyer. John hands this unrecorded deed over his lawyer, and says, well, this is just in case I die before Maurice, we'll just leave it with you. And then the lawyer's office has a fire and it burns down, but there's no controversy about that fact that this is what happened. So that's it. And now there's a fight. Who's fighting in this case? Go ahead.
Maurice's estranged wife. She's, I guess he died without a will.
Right.
And I guess apparently under law of Connecticut, she would be the property. And she's fighting that, that under the circumstances that he had lived on the property and was still paying taxes and I guess receiving the rents, that John, there was no effective delivery to John. And that's why she's claiming that it's her property.
Well, let's say he had a will and disinherited her. They haven't lived together for 20 years.
Well, then she would receive third? No.
Yes.
Oh, yes.
Yeah, the answer is yes. That's right. Under what theory do people get that? I think
Well,
this is why you need a teacher. I mean, I think that wasn't really too clear.
Dower?
There are, excuse me?
Was it Dower?
No. There are statutes that protect married people from being disinherited by their spouses. You are allowed to disinherit your children, but you are not allowed to disinherit your spouse, at least not entirely. After we're done talking, at the end of the section of the course on jointly held property, we will read New York's statute very carefully, partly to have experience reading a complicated statute. They call that the right of election. And here's what it means, here's why they call it that. If somebody leaves a will, you have, and leaves money to their spouse, typically people do, of course, then the spouse would just inherit the property under the will. But if they don't have a will, I'm sorry, if they disinherit their spouse, the spouse has the right to elect to take a statutory portion of the estate regardless of what the will says. In New York, if somebody dies without children, the spouse has the right to a third. I'm sorry, without children, the spouse has the right to half of the decedent's estate. The surviving spouse has that right. With estate being defined in a rather complicated way that we'll study later in the course. In contrast, if the decedent dies with leaving both a spouse and children, then the surviving spouse has a right to 1/3 of the estate. In fact, as you can imagine, it's not that unusual for somebody to disinherit a spouse and leave all their money to the children. So that happens in particular when the current marriage is with one person, but the children were from a previous marriage. So there's laws. When we talked about divorce and equitable distribution, we talked about one way in which the law protects certain people as a result of their having been married. We talked a little bit about what happens with respect to people who aren't allowed to get married. The law doesn't even recognize marriage, never mind people who just decided not to get married. This is another situation. The right of election applies to married people. It doesn't apply to people who aren't married. So we have, so now that's if you are, that's if there's a will. When there's no will, there's a statute which is typically called descent or intestacy. They say that when there's no will, people die intestate. And in that situation, there's a law giving the spouse a certain amount of money, and it varies considerably under different circumstances. We'll read New York's intestacy statute also, again, because the only way to see how this area of law works is by doing some fairly detailed statutory analysis. I've chosen New York's because most of you are going to choose to work in New York, even if you're not going to stay in New York. Hardly matters. These statutes are relatively typical of how statutes of those sorts work around the country. So that's really what's going on. It's Maurice's wife, who hasn't been together with him for 20 years, saying, I'm entitled to a piece of the estate. But of course, if Maurice doesn't own the property anymore, then she's not entitled to any piece of this house because he doesn't own it anymore. That's what they're fighting over. Now, years ago, this case is pretty old, and years ago, this case came up in 1940. It was much more common for people to separate and just not get divorced at all. There was no no-fault divorce back then. The liberalization of the divorce laws occurred decades after that. There were many more religious scruples about divorce, including the church not recognizing it. And there was more of a stigma to being divorced. Now it's not the least bit unusual. So there were lots of people like that. Now there are still plenty of people who separate and don't get divorced, sometimes for financial reasons. They just don't want to go through all of that. So whatever support arrangements there were continue. People just don't stay together. But there are potentially very serious problems with respect to these statutes for marriages like that. That's really what this case is about. Now, what about the law? What did the court say? Who wins this case? In the Supreme Court of Connecticut. Yes?
I think she did, because first I was confused because they were talking about two deeds and I wasn't sure which deed the court was focusing on. I think that they were focusing on the one that got recorded, and they said that in order for a deed to be valid, you need to have delivery and intent. And because there was that second deed that was always in the background, there was never really intent to give that first deed. And because of that, I think the court said that it never really went to John. It always was Maurice's property.
I'm not sure that was really the theory. You're absolutely right about the result. Maurice definitely gave that house to John. And if he gave the house to John, then it would be John's house. So there's got to be something about the second deed. That second deed has to be valid for her to win, doesn't it? If the first deed is valid, you could say that the first deed is not valid, which they don't. That's one way of having her win. Once the first deed's valid, the second deed has to also be valid. So it's either going to be, it's double or nothing. Either neither of them are valid or both of them are valid. I think the court says they're both valid. What was the, yes?
Yeah, that the second one was valid and it was legally delivered. So the original owner gave it to his brother, and then his brother gave it right back to him, and that was it.
Well, his brother just gave him a new deed, really. But he gave the house right back to him through a new deed, or the property right back to him through a new deed. So the question in this case was whether, when John gave the property back to Maurice, really with the understanding that that deed wouldn't count unless John died first. They said that condition, the court said, we don't recognize conditional deliveries like that. If you give somebody a deed and there's no conditions in the deed, then if you give somebody a deed that says, I hereby give you this property in fee simple absolute, and it has all the warranties that you read in the book a few minutes ago, then that's it. That's really what you gave them, and oral conditions just aren't going to count. In contrast, if you gave the second deed to an escrow agent with written conditions that the escrow agent is not to release this deed to Maurice except under the following circumstances, then the court would honor those conditions. Boy, does that seem tough for people just to be doing something like that. The court did not say you can't do what they wanted to do. The court just said they didn't do it well enough. So, why would the court be so stingy? The court's being pretty stingy here with John and Maurice. After all, they really did try to do something that you're allowed to do, and what their intent was pretty clear, yes.
Well, really, I think they just don't like the fact that Maurice was trying to get around the statute. And that's basically what he's trying to do, but his wife, we have been doing it for 20 years, to get this property.
There's a statute that says you can't disinherit your wife. If you don't have a will, your wife is going to inherit, or husband, or you can't disinherit your spouse. If you don't have a will, they'll inherit under the intestacy statute. And if you do have a will, there's a limit to how much you can disinherit them. So he has some kind of a scheme for disinheriting her anyway. Now, what's wrong with this scheme for disinheriting somebody? Just give away all your property. Then you don't have anything. Why can't you do that? Yes?
Well, I'm not sure, but I think because it would go against the statute of wills.
Well, let's say you really gave it away. For example, let's say that Maurice says to John, you know something? I can't get divorced for religious reasons. But the last thing I want is for her to inherit this property. That's crazy. So she's going to want her statutory 1/3, which is what Connecticut has. So I'm going to give you this property. You own it. And I'd like you to rent it to me for almost nothing, or for nothing. But it's your property. And I guess you have the right to kick me off, but I assume you won't, because we're close and we're brothers. And I understand that when you die, whoever you'd like to inherit the property can have the property. So what's wrong with that? Yes?
Like joint tenancy, he can't give away what's not completely his to give away.
Oh, the house wasn't owned in joint tenancy.
Oh, and her name wasn't on the deed.
Let's assume not.
But isn't it statutory that the couple's assets are considered to be held together?
No. Well, it depends on the purpose. For divorce, the answer is yes. And so equitable distribution really doesn't matter what the title is, as long as they acquired the property during the marriage. But upon death, it really doesn't work that way. It's much more formal. So any property in the name of one spouse.
Well, are you saying if he dies intestate or if he dies intestate?
Either he died intestate, or he died with a will that left the money that left all his property, his wealth to somebody else, but disinherited his wife. The same issue is going to come up. That is, from her perspective, if I can show that he owns this house, I'll either get my intestate share or I'll get my statutory elective share, but I'll get something. So that issue doesn't really matter very much. When they talk about the right of election in this book, the impression is that there was a will that that just didn't give her anything, or they probably wouldn't have been talking about that statute. But it really doesn't matter which of those two ways this all happens. Yes?
I don't understand why they bother doing this scheme. Couldn't John have just written a will that says if I die, property goes back to Maurice?
Yes. He could have left the property. Maurice could have trusted him just to leave the property back to Maurice, so that Maurice would get it and then have to take his chances. That's something that would have worked. You would have had to require John to write a will, and you'd have to trust him not to change the will if there was some kind of falling out. But absolutely, that would have worked. What else might have worked? Think back to the Gruen case. The hands just went down. Or white versus brown. Think about the concepts that we looked at. Yes?
Well, if Maurice deeded the property to John and then John gave it back to Maurice as a life estate.
Yes, that would work. So now, in essence, what's happened is one way or the other, John has only a life interest and Maurice has the remainder interest. I'm sorry, vice versa. Yeah, Maurice has the life interest, so he can either deed a remainder interest right then, or he can have an exchange where Maurice owns the property and deeds back a life interest to his brother. Either of those would work. That would work fine. What else does it, the things we haven't talked about yet, there are other things, but some of you know about these. What kind of ownership is there any way that they can own the property together? Yeah.
Is it joint tenancy?
Yes,
With right of survivorship?
exactly. And the next thing we talk about after this section of the course is going to be landlord-tenant. Right after that, we're going to be talking about joint tenancy. There are three kinds of concurrent ownership that we'll talk about. One of them would be relevant to this. There's something called tenancy by the entirety, which is available only to married people, so that wouldn't work. But there are two kinds of concurrent ownership that are relevant. One of them is called tenancy in common, which has no right of survivorship, so they wouldn't want that. But the other is joint tenancy, which includes a right of survivorship. So Maurice could have deeded the property from himself to himself and John as joint tenants with right of survivorship. Then, if he died, this would not be part of, well, it may not be part of his estate. We'll see that it would not defeat the right of election, actually, if we've done it that way. But survivorship rights don't really have problems with the right of election. So we'll see that there are all these possible schemes to try to disinherit spouses. That's what we're talking about now. How can you scheme to make sure that your husband or wife doesn't get anything, even that there are statutes that require them to get something? And when we look at the statute, you'll see that the statute, I don't want to go into the details now, but the statute plugs up some of these holes that seem to exist. And it doesn't plug up others with respect to disinheriting spouses. It's really pretty interesting. So actually deeding property to oneself and another in joint ownership does not defeat the right of election, in New York anyway, because there's a rather complicated statute that specifically says that it doesn't. Now that, often that wouldn't happen so much with brothers, but it happens with children. So somebody says, gee, you know, I really don't want your stepfather or your stepmother getting my money, but I don't want to just give it to you now because I'm still here and I still can use it, but I really trust you. So would it be okay if I transferred my wealth from myself to a joint account that you and I both have, so it will not pass through my will when I die because you'll be the survivor and automatically get it? And the child will say, sure, and as a dutiful child, just won't do anything, just pretend it didn't happen. Then the parent dies, and the question is, what happens then? And the answer is that does not defeat the right of election, because the statute is drafted very carefully to take all of these shenanigans out. And the real question is, are there shenanigans that are left after you read the statute? So when we talk about that statute in detail, it's not the right time to be dealing with that now. But when we do talk about it, we'll come back to the Sweeney case. Yes?
Can you just repeat the way that a life estate could have been structured in John and Maurice's case? Was it that Maurice could have given John a life estate, and then after John's death it goes back to Maurice? But would it have to be the other way around, that he gives him the entire property and then John gives him back the life
That's
estate?
what I was assuming.
It couldn't be
initially.
the other way around?
I think it might be. I think maybe you could do it the other way around. I hadn't thought of it, but I don't know why you couldn't do it both ways. But my understanding was that I mean, as I thought it through, I thought it through the way you had just suggested. Anything else?
Can I change the tape?
Go ahead.
Okay.
We'll take a break.